esteemed viewers, followers and subscribers, and welcome to another exciting edition of Let's Talk with Accent Litigation. It will be exactly 22 days and 17 hours to the general election as scheduled by the Independent National Electoral Commission. The question is, with political parties jostling for votes of electorates through their campaigns and rallies, and electorates pitching tents with several candidates, and a significant number of them undecided, and candidates spending humongous amounts of money to ensure their victory. The right question to ask at this time is, how many of these candidates knows their rights under the electoral laws of Nigeria? As usual, we'll begin with a story. I have a friend in the southern part of Nigeria. He is a member of a prominent political party, and this party had a governorship election in which his preferred candidate won the election. Basking in the euphoria of that victory, it came as a shocker to him when 6 months after that election victory, the Election Petition Tribunal nullified the election of his preferred candidate and declared another candidate the winner. He is confused as to what will be the fate of this preferred candidate of his, and moving forward, if that preferred candidate will still remain in office as the governor of that state. With this, I introduce you to the topic of today: rights of candidates under the electoral laws of Nigeria. In understanding this topic, we have tried to divide it in such a way that our viewers, will be able to follow. We'll be discussing who is a candidate, the rights of the Independent National Electoral Commission to conduct elections in Nigeria. We'll be discussing the rights of these candidates, and also what happens when a candidate dies in an election. Now, who is a candidate? A candidate simply means a person who, after not being nominated by this political party, has his or her name submitted to the National Independent Electoral Commission and chosen as a flag bearer of that political party. This candidate has, first of all, to be a Nigerian citizen, must be of age, and of age is as stipulated in the Constitution. That is to say, for you to vie for the position of a president, you must be up to the age or attain the age of 40. And for you to vie for the position of a governor or the Senate, you must have attained the age of 35. To be a House of Representative member, you must attain the age of 30. Why? To vie for the position of membership in the House of Representatives of any state, you must be up to the age of 25. In the definition of candidates, as we earlier stated, you will find out that for you to be a candidate, there are 3 important and fundamental elements that must be present. Number 1, you must have been sponsored by your political party. Number 2, you must have participated in the process that brought you or produced you as a candidate of that political party. And number 3, that political party must have submitted your name to the Independent National Electoral Commission as its own candidate for an election. Having said it, and you now know who a candidate is, and that a candidate is different from an aspirant, because every other person who contested a primary election is known as an aspirant, but only the victor from a primary election is known as a candidate. And for him to stand election as a candidate, the political party must have sponsored him, must have submitted his name to the Independent National Electoral Commission, and he must have participated in all process that brought him as a candidate. We go to the second item, which is the powers of the Independent National Electoral Commission to conduct elections in Nigeria. Basically, the primary law that empowers the National Independent Electoral Commission to conduct election in Nigeria is the Constitution of the Federal Republic of Nigeria, 1999, as amended. The Constitution itemizes certain functions to be carried out by the Independent National Electoral Commission, otherwise known as INEC. One of which is the power to conduct elections. Only the Independent National Electoral Commission has the powers to conduct a general election. And by general election, we mean election into the position or office of the president and vice president, election into the office of governor and deputy governor, and election as a member of the National Assembly, being the Senate and the House of Representatives, and as a member of the state houses of assembly. And lastly, as a chairman or member of an area council in the Federal Capital Territory. This is the gamut or the scope of powers of the Independent National Electoral Commission to conduct elections in Nigeria. Another important powers of the Independent Electoral Commission is powers to register political parties. Only INEC has that power to register political parties. Not even the courts can register political parties, but just INEC. Also, it has the power to monitor and organize operations of political parties. By this we mean, it is only INEC that is saddled with the statutory responsibility to monitor the congresses and conventions of political parties, and also to supervise their spending and scrutinize their finances. No other body has the powers to do this except the Independent National Electoral Commission. Also, it has the powers to prepare voters' register and print out permanent voters' card. And this is very important, because very soon Nigerians will be going to the polls. And it is only the Independent National Electoral Commission, otherwise known as INEC, that can print out voters' register, which will be placed at each polling unit for identification by prospective voters and electorate within a polling unit. And they are the only ones responsible for the issuance of permanent voters card. Also, part of the powers of INEC include to provide regulations to govern campaigns and political parties. These regulations goes as far as determining how much or the amounts to be spent by each political party in executing their campaigns. Later on in the course of this discussion, we will get to the amount allowed within the ambits of the law that can be spent by a political party and its candidates during an election. Now we'll discuss the rights of candidates within the electoral laws governing Nigeria. There are basically two legislations that govern electoral processes in Nigeria. The first being the Constitution of the Federal Republic of Nigeria, which is the primary law, and the second being the Electoral Act of 2022. We'll start with the Electoral Act of 2022. The Electoral Act stipulates key rights of candidates vying for positions in a general election. Number one of these rights is the right of a candidate to have his or her name submitted to INEC by his political party not less than 150 days to the date scheduled for the election. First, before being a candidate, he was or she was an aspirant. And having emerged victorious from the primary elections, either by direct or indirect primaries or by consensus as stipulated under the Electoral Act, it is within the rights of the candidate that his or her political party submits his name or her name to the Independent National Electoral Commission within 150 days to the election. Failure to do this, the candidate has a right to apply to court to grant an order compelling his political party to submit his name to INEC. And once the 150 days elapse, it is only by order of court that a candidate's name can be submitted to INEC. So it is important that candidates, not just in this present election, but in subsequent elections, should take note of this. Secondly, candidate has the right to have his name published by the Independent National Electoral Commission in the constituency where he is vying for election within 7 days after submission of his name by his political party. This means that after the political party must have submitted his name not less than 150 days to the date scheduled for the election, it is the duty and responsibility of the Independent National Electoral Commission to publish the name of such candidates at the constituency where such candidate is vying for an election. That is to say, if it is a candidate of the vying for a position seat in the National Assembly, his name must be published within the senatorial district or within the federal constituency where he is contesting such election, as long as his name has been submitted to INEC within 100 or less than 150 days to the date fixed for election. Another right of the candidate is the right to withdraw his candidature. In politics and also within our electoral space, there is rights of free ingress and ingress. By that we mean rights to free entrance and exit. A candidate who willfully submitted himself for election or selection by whatsoever means by his political party, after his emergence, has the right to withdraw such candidacy of his from contesting the general election. And this right of his is inalienable. That is to say, it cannot be stopped. It is an inherent right every candidate possesses. But there is a caveat. Why a candidate can apply for a withdrawal of his candidature, the candidate must do so not less than 90 days to the date scheduled for election. That is to say, if the candidate submits his notice of withdrawal 89 days to the date of election, INEC is bound to decline such notice, and the name of such candidate will still be on the ballot, irrespective of the fact that he had or she has published or sent a notice of his or her withdrawal. And this notice of withdrawal must first of all be submitted to the political party that nominated such candidates, and it must not go straight to INEC without first submitting it to the political party. Also, another important right of the candidate is the right to have his name published on the website of the Independent National Electoral Commission 150 days before the election, and such name must continually be on the website until the election is concluded. It is the right of every candidate to have his or her name published on the website of the umpire, being the Independent National Electoral Commission, and such name being published must remain on the website until after the election, or by order of court can such a name being published withdrawn or put down from the website of the umpire INEC. Anything outside this is an infringement and an affront on the rights of the candidate and is unacceptable. Also, another right of the candidate is the right to be consulted by his political party before selection of polling agents for the election for which he is standing. That is to say, the political party does not have within its powers to unilaterally select and appoint polling unit agents without consultation and input from the candidate. Also, the candidate has the right to nominate himself as a polling agent. That is to say, that if where the political party decides to forward names of polling unit agents without consultation from the candidates, that will be a breach and a violation of the rights of the candidates. Although this breach cannot result to the voiding of the election or to the nullification of the results of the election as declared by INEC. Another right of the candidate is the right to countersign the result sheet as reported or as produced by INEC. After the umpire, the Independent National Electoral Commission, must have collated the results and announced same, the result is imputed in a result sheet, and where the candidate is available or his agent is available, they are to sign the result sheet. That is authentication of the result. But this right comes with exceptions. The first exception is where the candidate or his polling agent is available. The second exception is where, though available, the candidate or his polling agent refuses to sign or countersign the result sheet. Once he refuses to countersign the result sheet, he has waived this right, as long as he was given the opportunity to sign or countersign the result sheet. Also, the candidates who are present in a polling unit has the right to order or to ask for a recounting of the results in a polling unit. Emphasis on in a polling unit. Every candidate who is present in a polling unit has the right, after counting of results of ballots of that polling unit, to demand for a recount of the ballot papers. But this right to recall counting of the ballot papers cannot be exercised more than once. That is to say, after the first count, if there is a requisition or if there is a request for recounting of the ballot papers, another order cannot come for the recounting as long as it has been recounted once, not more than once. And that is the position of the Electoral Act. Having explained this, we'll get down to the rights of the candidates under the Constitution of the Federal Republic of Nigeria, 1999, as amended. The Constitution provides for the rights of the candidates to contest or contend the results as issued by the umpire, the Independent National Electoral Commission. In contending this result, the candidate has, within 21 days after the declaration of an election result, emphasis on 21 days after the declaration of an election result, to challenge such results before the Election Petition Tribunal. Failure to challenge such results within 21 days after declaration of the result, the candidate is deemed to have waived his right of challenging the results. Also, where the candidate has challenged the result within 21 days, the Election Petition Tribunal is mandated to give its verdict on the election and on the petition written by such candidates not less than 180 days. That is to say, the Election Petition Tribunal cannot give its verdict after 180 days from the date the candidate filed the petition challenging the result or outcome of the election. Also, where the candidate feels that the decision of the Election Petition Tribunal is not in his favor and he has the right to appeal, that right to appeal is inherent in him. That is to say, it cannot be taken away from him except he waives that right. This brings us to the right of exhaustion of appellate jurisdiction of the court. Where the candidate contends the results or the verdict of the Election Petition Tribunal, such candidate has within 14 days after declaration of such results to file an appeal challenging the verdict of the Election Petition Tribunal. And upon receipt of the appeal, the Court of Appeal has within 60 days to give verdict on the appeal. That is to say, if the candidate went to sleep and refused to challenge the decision of the Election Petition Tribunal, and on the 15th day he decides to challenge that petition, that result or that verdict, he will be said to be out of time and have waived his right to appeal. And the Court of Appeal is always mindful that it has only 60 days from the date the candidate, the aggrieved candidate, files the appeal to give verdict on such appeal filed by the aggrieved candidate. Having explained this, I hope you now understand and know the scope of rights of candidates within the electoral laws of Nigeria. We'll now go to the last segment, which is what happens where a candidate dies in or within an election period. Now, what the law provides is that where a candidate dies less than 14 days to the date fixed or scheduled for election, the party who nominated such deceased candidate has within 14 days from the date such event occurs to conduct a fresh primary to produce another candidate, which candidate will now replace the name of the deceased candidate. And the Independent National Electoral Commission has the powers to shift the election or postpone the election not more than 14 days. However, where the candidate dies within a period beyond 14 days to the date scheduled for the election, the political party who nominated the candidate who eventually died has the powers within 14 days to conduct fresh primaries and then submit a name to replace the name of the dead candidate. But the election will still go on as scheduled. And lastly, where election has begun, but before announcement of results or declaration of results, a candidate dies, the position of the law is that the running mate to such deceased candidate shall step into the shoes of the deceased candidate and inherit his or her vote, and afterwards nominate a running mate for himself or herself. And these are the express provisions under the Electoral Act 2022. I hope with this discussion you have been enlightened on the rights of candidates, and beyond that, what happens when candidates die within an election period. Thank you very much for having listened to us. Your suggestions and questions are welcomed, and you can do that at the comment section of whatsoever streaming platform you can watch us from. Please note that we are always eager to hear from you and receive your feedback. Until we meet again, thank you and God bless you.